going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chunky! I didn't say.
Eat your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you're having a great day so far. I've got a good one. This one's spicy. We've got a throuple. Someone's in jail over a throuple. And yeah, it's interesting. Yeah, good arguments on both sides. I'm looking forward to seeing what you guys say about this one in the comments. But yeah, I had to play it. It's a throuple. It's spicy. Let's do it. Before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
I think so, Judge.
All right, we're going to go ahead and have this hearing. All right, sir, are you Mr. Baban Citron? All righty. We're about to have your bond hearing. This is the State of Georgia versus Citron. Let me mute that. Charged in warrant number 2024 CW 74010, aggravated assault, 2024 CW 74011, aggravated battery, 2024 CW 74012, weapon possession during a crime, 2025 WA 71654, aggravated assault of an officer, 2025 no, I'm sorry, he just has the 3 charges.
That's correct, Your Honor.
I'm sorry. So he has 2024 CW 74010, so 010, 011, and 012, aggravated assault, aggravated battery, and weapon possession during a crime. Representing the state is ADA Thomas, representing Mr. Citron is Attorney Thomas Florio. Thomas Florio, your witness, or your case. Make your case.
Yes, Your Honor. Your Honor, I will start with opening. I don't have any other witnesses, so it'll just be Judge. I know this honorable court didn't preside over the preliminary hearing on Wednesday, but just to provide the court with what we believe the factual basis of this case would be. This is an incident, Your Honor, that occurred back on July 16th, 2024 at Mr. Citron Paybone's home. Mr. Citron Paybone had been dating for a few weeks a young lady named Kimberly Arroyo Jacobo. Unbeknownst to Mr. Citron Paybone, Ms. Arroyo Jacobo had been dating the alleged victim in this case for evidently even longer than she'd been dating my client. Essentially, this woman was dating 2 men at the same time. My client did not know that she had a boyfriend, and her boyfriend did not know that she was dating my client. On the early morning hours of July 16th, 2024, she came to my client's home at 3 in the morning. Her own admission was to party with my client. At some point thereafter, she communicated with her boyfriend and asked her boyfriend to come to my client's home to pick her up. She then fell asleep. Her boyfriend traveled from Gwinnett County down to Clayton County, arrived at my client's home at approximately 6:30 in the morning, and began knocking on my client's front door.
Okay, let me make sure I understand. The victim asked her boyfriend.
So the boyfriend is the victim.
Oh, the boyfriend is the victim, but his girlfriend or somebody he was dating asked that the boyfriend come over to his house.
That's correct. She was sleeping with 2 men at one time, and neither man knew that she was sleeping with the other one.
Okay. All right.
And so she's at my client's home having sex with my client. Once she finishes having sex with my client, she messages her boyfriend and tells her boyfriend to come pick her up. My client had no idea that she had a boyfriend or that she had messaged her boyfriend to come pick her up. So she shared her location with her boyfriend. Her boyfriend came to my client's home and began to beat on my client's front door looking for his girlfriend, which is perfectly reasonable.
Right.
She told the police that she had fallen asleep. And so obviously when her boyfriend got there and he's texting her and calling her and saying, come outside, she didn't respond because she was asleep. My client got out of bed. My client went to the front door and my client was confronted at the front door by the victim who was her boyfriend. The two men at that point, I think, figure out that, they're both sleeping with the same woman. There's an allegation by the officer that the victim then gets back in his car and leaves. There is then an allegation by the officer that the girlfriend messages her boyfriend and says, come back. He comes back to my client's house. There's then an allegation by the victim that he is confronted by two Hispanic males in a white SUV, that both of the Hispanic males have firearms and that both of the Hispanic males shoot at him, and he is shot one time in the knee. This all occurred in July. Law enforcement responded to my client's home. They did not see a white SUV in my client's home. They searched my client's home or did a sweep of my client's home, did not find any firearms in my client's home. The girlfriend told the police, this is where Gene lives. This is Gene's name. This is Gene's phone number. And law enforcement did nothing with respect to this until December when warrants were issued for Gene. The detective testified that she did do a subpoena for cell phone records, and that the cell phone records placed Gene in the area at the time of this incident, and that's what she wanted to confirm before she issued a warrant for him. She also testified that she was really busy with other cases, and that also attributed to this incident having occurred in July of last year and warrants not being issued for my client until December of last year. My client was arrested March 18th at his home. So in the 8 to 9 months after this incident, my client did not leave the jurisdiction of the court. He did not leave the county. He did not leave the state. He did not leave his home. He continued to reside at his home where this incident occurred. The detective also testified that in the last 9 months between this incident occurring and today, she has no proof of my client messaging the alleged victim, calling the alleged victim, attempting to communicate with the alleged victim, going to the alleged victim's home, nothing. There has been nothing between these two gentlemen in the last 9 months since this incident occurred. And I think that's important because Ms. Thomas has intimated to myself and obviously intimated to the court that she was not inclined to consent to bond because the alleged victim is scared of Mr. Centrone Paybone. The only issue is that in the 8 months after this incident that Mr. Centrone Paybone was not in custody, he made no attempt to communicate with the alleged victim. So any concern that Mr. Centrone Paybone would now all of a sudden pose a threat to the alleged victim is certainly dissuaded by the fact that in the 8 months after this incident, there was nothing between the parties. And in the 30 days that my client has been in the custody of the Clayton County Jail, there's been still nothing, either by Mr. Centrone Paybone or by any member of Mr. Centrone Paybone's friends or family. The detective also testified when I asked her, what proof do you have that Mr. Centrone Paybone possessed the firearm that shot the victim? Her answer was, I have none. She has no proof that Mr. Centrone Paybone was the gentleman that shot the victim. Mr. Centrone Paybone, Your Honor, we believe has one prior arrest for driving on suspended license. That's it. He has resided here in the county for 11 years now. He resides with his family, that being his mother, his father, his brother, his sister, nieces, nephews. His mom and dad and other close family members reside at this home. His sister, brother-in-law, nieces, nephews live in a house down the street. And they have all resided in the same area for the last 11 years, Your Honor. He is employed. He works full-time as a mechanic here in the county. detective testified at the preliminary hearing that she has no proof that he has ever purchased a firearm, no proof that he possesses a firearm. She testified at the preliminary hearing again as to no contact between he and any alleged victim in this case, no attempt to try to, there is no proof that he has tried to flee, that he has tried to flee the jurisdiction of the court, no proof that he has made any attempt to obstruct any sort of justice with respect to this case, no proof or evidence that he's made any contact with any witness or alleged victim in this case. We believe that the girlfriend, who is the center of this case, he and her have maintained the relationship. And within days of him being arrested here in Clayton County, he was in the company of the young woman, still engaging in sexual relations with this woman. And so this, I don't think he understood what had happened. He had no clue until we received these warrants as to what I've just told you. We had no clue that she had a boyfriend. We had no clue that the person that came to our house and was beating on our front door was her boyfriend. All we knew was that there was a stranger that we did not know at our home at 6:30 in the morning, beating on our front door, upset that we were in the company of this woman. That's all we knew. And so, Judge, we don't believe with respect to Ayala that any of the Ayala factors weigh against us. His criminal history is virtually nothing. He has no prior felony arrests, no felony record. He has an arrest for suspended license. In the 8 months that he was out, he made no attempts to flee the jurisdiction of the court. In the 8 months that he's out, he made no attempts to make contact with the alleged victim. We believe that there is no Ayala factor that weighs against us with respect to this case. This is a case of someone coming to our home and us defending ourselves and our property. We would ask that bond in this case be set an amount of $35,000. I think it respects the allegations in this case, but also respects his lack of criminal history, respects factual issues with this case. We would abide by any and all terms and conditions that the court would impose. Certainly no contact with the victim. We have no firearms, so there is no firearm for us to surrender. He has no passport, so there is no passport for us to surrender. He lives in Clayton County. We believe the alleged victim lives in Gwinnett County, so the likelihood of them having any contact or running into each other is virtually zero. They don't run in the same social circles, but we would abide by any bond restriction that this honorable court deemed necessary. Thank you.
All right. Well, you got the story. And I'm going to start off with saying, as my friend Biggin would say, don't put your D in crazy. And he's still in a relationship with her. Why would you be in a relationship with someone that puts you in that situation? I don't understand. You're in jail because of her. Doesn't make sense. But let's walk through this. So this lady calls up her boyfriend to come pick her up and then passes out, and he's banging on the door. Now, I don't like the word banging on the door, because when I hear that, I think he's aggressive. He's banging hard on the door, and that would get the attention of everyone in the house. Why didn't the girlfriend say, "Oh, that's I know who that is. I'll de-escalate the situation"? She just stood back. There's a lot going into this, and I think, yeah, I mean, but at the end of the day, someone was shot, so it's a serious crime. Yeah, and I understand why he's in jail. It's just so weird. I'm gonna stop. Let's watch the rest of this. The prosecutor's about to speak. Maybe she'll answer my questions for me.
All right, Thomas.
Your Honor, I have a victim that is extremely afraid for his own personal safety, and I do understand what Mr. Florio was saying regarding there's been no contact between the parties since the incident. However, the victim was shot in his knee, sustained significant damage and injury to that knee, and is still undergoing treatment from my understanding. Now, the key thing here, and the reason why I do believe this gentleman is a significant risk of a threat or danger to the community, is that something that Mr. Florio said, and it actually caught my eye. I was like, okay, this is really what it's all about. When he, in his recitation of the facts, indicated that the victim was knocking on the door of this defendant, trying to pick up the young lady in question, Mr. Florio described that as being perfectly reasonable, because it was. it wasn't the type of behavior that would have warranted this gentleman coming out, shooting, he and another gentleman that was identified by the witness in this case, the alleged girlfriend, shooting at this vehicle. Nobody was shooting at their house. Nobody was yelling or at anything, any kind of type of factor that would merit someone coming out their house shooting at a car. The defendant had the opportunity to ask the young lady, hey, do you know who this man is that's knocking on my door? As Mr. Florio indicated in his recitation, the witness called this man to come pick her up. She then called him again and asked him to come back to pick her up. He had opportunity the first time to say, hey, who are you calling? Why are you calling? Why are you leaving? Well, any number of things. He did not. His reaction was, and it's notable, he didn't start shooting until the victim returned. When the victim returned, the victim was in his car. He didn't go back to the door. He actually stopped to try to pick her up off the side of the street as she was leaving the defendant's residence. So he would not have had a reason to be upset about someone knocking on his door that second time, because the victim didn't even go to the door the second time. It's my understanding he was still sitting in his car. From what the detective testified to, she described the vehicle as being shot up because the victim was sitting in the car, and that's how he got hit with one of those bullets coming through the car and struck him in the knee. So again, if you're thinking this guy is a threat to you because he's standing on your doorstep, that's one thing. But apparently he didn't. He didn't start shooting. He and the other individual involved didn't start shooting at this victim until the victim circled back around per the request of the witness to pick her up. So he was nowhere near the house, didn't shoot at the house, didn't do anything other than stop to pick up this witness. And that's how the witness saw everything, because she's standing there as they're coming out of the house shooting at this man. Your Honor, that to me represents a significant threat or danger to the community. Who knows who he'll do it? Who else will get treated that way? So at this point, and regarding his criminal history, Mr. Florio is correct. He has no history in Georgia that I can see. However, he is a multi-state offender. He has convictions in Alabama, had a conviction in Alabama and another conviction in Florida. That Florida conviction being a grand theft in the third. So,
and when was that?
we're not looking at somebody, ma'am.
ADA Thomas, when was the grand theft?
That was in 2018. The offense in Alabama was also 2018.
And what was the other one?
That was possession of marijuana in the second, Your Honor.
Is that a felony or a misdemeanor?
I couldn't tell, Your Honor. I kind of lean toward being possibly a misdemeanor, but it may not have been. I'm giving him the benefit of the doubt on that one. So we're not looking at somebody that's pure as a driven snow here. This is somebody who has been through the system once or twice. Common sense would tell you, if the man is out there on the street, he's not on your doorstep, he hasn't manifested any threat to you either time, why would you shoot at him? I don't get it. The young lady that you profess to be in a relationship with, she's standing right there talking to him. She doesn't appear to manifest being threatened or anything. Again, why would you shoot at this man? So I can understand why the victim is in fear, because in the victim's mind, he didn't do anything. And as Mr. Florio said again, he did a perfectly reasonable thing. He knocked on the door. He was there to pick up this young lady. I don't know what the relationship is. And it really doesn't matter, to be honest with you, Your Honor, because Mr. Centron Pabon decided to start shooting, even though this man had done absolutely nothing to him. So again, state would ask that the court set a bond the state set a bond that would reflect the seriousness of this offense. This is somebody who feels that it's perfectly appropriate at a residence that I believe Mr. Flory indicated he has significant number of family members. He comes out the house shooting. Who does that? So I would ask the court to set a bond appropriate to the seriousness of the charges before it.
All right, thank you.
All right, I mean, I agree with some of what she said. I don't know why the situation was escalated high enough where you thought a firearm was necessary. But at the same time, if someone you don't know is banging on your door, they keep using the word banging, so I'm going to assume that he's knocking aggressively. and you don't know who this is, you know, I don't know. Again, why the girlfriend didn't say, "Hey, I can fix this problem. I can send him home," and then that would have sparked a whole nother type of conversation. But at least no one would have got shot. Especially the girlfriend had to know that this guy was, he grabbed a gun. Uh, and then he shot at him while he was retreating back into his car. That's a big red flag to me. There was no need for that. If he was leaving, why are you shooting at him while he's in a car? That doesn't make sense to me. Yeah. Anyways, still, Throuple gone wrong. Don't put your D in crazy. Now I've said it twice. I gotta give Big credit for that twice. All right, let's finish this one up.
So I have a
Judge,
few.
may I
Oh,
just
absolutely.
respond to
Get the
one thing
last
you
word.
said? Judge, and I'm glad Ms. Thomas brought it up. So I asked the detective, there is Ring doorbell footage. We have the Ring doorbell footage. The Ring doorbell footage, once the victim gets in his car and pulls off, you hear 2 pops. I asked the detective if does she recall listening to the Ring doorbell footage and seeing the victim get in the car and pull off and hearing the 2 pops. And her response was, I can't recall. The alleged victim shot at my client's house as he pulled away. We genuinely believe that. It's on the Ring doorbell footage that she took from my client's house. Her testimony being, I don't recall if it's there or not. Certainly, if there was no proof of it, I think the response would have been there's no proof of it. But you hear 2 pops as the gentleman gets in his car and pulls away from my client's house. And the act of him knocking on my client's door at 6:30 in the morning absolutely was reasonable. But when my client opened the door and then he figured out his girlfriend is in another man's home, that's when this situation escalated. So yes, him knocking on the door was certainly a reasonable act. But when he figured out that his girlfriend was in my client's house having sex with my client, that's when the victim escalated this incident.
Yeah, I would object at this time. There's been no testimony that the victim did anything other than pick up the witness in this case. There's been no testimony, and notably,
The bond hearing,
there's an allegation that there were 2 pops. There's been no testimony to indicate where those pops came from. That could have been a backfired vehicle. It could have been anything.
Judge, I'd object to this. This is a bond hearing. Hearsay is admissible.
Yeah, hearsay is admissible.
I can go into
Your Honor, there is no hearsay to it. It's an allegation by Mr. Florio. The detective indicated that she doesn't recall, and that's it as far as the testimony that was presented.
You don't know who told me this.
It's from Mr. Florio.
Attorney Florio, just move on. Just move on to your next point.
Yeah, he just objected to an objection. Before the judge even ruled about the objection, he objected. Oh, this is hey, we got some action in this case. That was good. That was fun.
Those would be my 2 points, though, as it relates to the 2 pops and also as it relates to the incident. And I have viewed the video, and I was told the contents of the video by someone else, which is hearsay, which is admissible in this morning's hearing. Thank you.
All right. So this case is quite disturbing to me, and it's more disturbing, Attorney Florio, that he's still dealing with this woman. That's what's disturbing.
Thank you, Judge. Thank you. I feel vindicated now. Thank you.
This victim, excuse me, not the victim, but the girlfriend of both parties, I believe, is the true defendant in this case. ADA Thomas, one thing I wanted to correct was that the grand theft was not in 2018, it was 2014. So I don't see anything after that. And then the one before that was 2012. I also like to mention that this all occurred as the defendant is in his home. This defendant is not out going to anyone's house, knocking on anybody's door. From what I've heard, I didn't hear the preliminary hearing, but from the recitation of the facts, I don't, it's a lot of evidence that's missing. And so I know this is not a trial. This is just this is just a bond hearing. Probable cause has already been found. But this is what I am going to do. Because the mere fact that the victim, Mr. Strickland, after he knows now that this is his girlfriend is cheating, he comes back to the location. I don't understand that. Why would you come back to the location?
If I may be heard, I believe Mr. Florio actually answered that question. I don't think the victim, actually left. The witness asked him to return to pick her up. So it's like he circled around to come back to get her.
So your position is that he didn't know where he was picking her up from.
He knew where he was picking her up, but when nobody responded, he attempted to leave. She calls him that second time, and he comes back to pick her up. He doesn't go back to the house. He picks her up because she had already left the location and was walking down the street. That's how she saw what happened, because she was standing there next to the car. She hadn't even had a chance to get in the car when they came out of the house shooting.
Okay.
All right, well, that changes things a bit. The girlfriend was no longer even inside the house. She had already left? Why did he brandish a fire? Okay. All right. That changes things. I feel like all of my opinions don't matter anymore. What were you doing, guy? Besides putting your D in crazy. All right, Biggin times 3. All right, let's let this play out.
All right, so I am going to set a bond. Thank you for that, ADA Thomas. That did clear that up. On the aggravated assault on 010, I'm going to set a bond of 10,000. On aggravated battery, I'm going to set a bond of 8,000. And then possession of a weapon during the commission of a crime, going to set a bond at 5,000. I'm not sure what that adds up to, but 10, 18, 20, 18, 19, 20, 21, 22, 23,000. No contact with Dominique Strickland. And Mr. Citron, if I were you, I would probably find myself a new girlfriend, because this could become a problem with the next boyfriend that she has. And so if anybody is causing my life to be at risk, whether it's being shot at or incarcerated, my freedom being taken, I would walk away. But we all have choices, right? All right, so that's the order of the court, no contact. Any other special conditions, ADA Thomas, that you can think of? Oh, I want to put in there, may not possess a weapon.
No violation of the law, Your Honor.
Okay, and may not possess a weapon.
And I'm assuming that Mr. Florio is going to be preparing this, or the court.
I can prepare it, Your Honor. If you'll give me 15 minutes, I'll email it to Your Honor and to Ms. Thomas.
All right. So you got everything, 23, no contact, and may not possess a weapon.
Yes, Your Honor.
All righty. And of course, may not violate any laws while you're out.
Yes, Your Honor.
Okay. All righty. Thank you.
Thank you, Your Honor. That concludes our business before the court. May I please be excused?
Yes, have a great one.
Thank you, Your Honor. Thank you, Ms. Thomas.
You're welcome.
Mr. Citron, don't disappoint me. Don't disappoint your attorney. All right? Stay out of trouble. Get through this. All right. Good luck to you, sir.
All right, that's it. That is it. This was a weird one, I know. A little bit more serious than cases I usually cover. When I heard this originally, I had a lot of opinions, and then after hearing it a second time, my opinions have changed. Let me know what you guys think in the comments. Yeah, that's all I got. I'm just going to close out the video. Have a great day. Have a great Easter weekend. Don't do anything dumb. You do not want to end up on my channel. I promise you. You don't want to. Unless you're on the panel, then you're more than welcome. All right, you guys are awesome. Please hit that like button. Until next time, bye.